And that will normally be in a motion or a brief or something like that that is filed in the court. Normally when you're reading a decision, the case caption will include every party exactly as it appeared in the original complaint. They will change nothing. So if you put a little funny in your case caption when you're filing your complaint, guess what? That'll be showing up in the original case caption for whenever that case is published. Now, once they get that original case caption and all the parties listed, then what will happen after that is they'll just list the first party. For example, I'm involved in a case called Smith v. Sandridge. Well, what happened was after the complaint was filed, every motion after that, all it said was Barry Smith versus John Thomas Sandridge, comma, et al., E-T-A-L, with a period after the A-L. And what that's saying is there's a whole bunch of other parties, but we're not going to bother to keep typing them over and over and over every time we file a new motion. And another word that you'll see that I was kind of impressed with, the judge says, we'll address these issues seriatim, S-E-R-I-A-T-I-M. And basically what he's saying is we're going to address the issues in the same order that they were raised.
So some of you are probably wondering, now that I have knowledge of all these books in the law library, what am I going to do with them? And there's a number of ways that you can springboard yourself into researching on a particular topic. For example, if the IRS sends you a notice of levy or a notice of lien, it's going to have numbers and letters on it. It's going to send you to a particular section of the United States Code that gives him the authority to do that. A friend of mine, he got paperwork from the Securities and Exchange Commission, and in that paperwork it cited the particular acts and statutes and rules and regulations that they relied upon to send him that paperwork. And so all he needed to do then was bring those down to the library, look them up in their respective books, and as soon as he did that, inside those books are annotations, and then you start reading the annotations. Pretty soon you come to cases that you're interested in, then you cross those over and go look them up in Federal Supplement or Federal Reporter or in the Supreme Court Digest, or Supreme Court Reports or Reporter, and now you're on your way to doing that. For example, I got a ticket for reckless driving. I'm familiar with the void for vagueness doctrine, which says that I must be able to know in advance exactly what behavior is prescribed by the statute. I looked at the reckless driving statute, and I'm like, they can call anything they want reckless driving. And how can I know whether I drove reckless in advance? And so I was thinking, how could this statute be on the books for so long and never have been struck down by any court or challenged by an attorney? So I took the statute that I was cited with on the ticket. I went to Colorado Shepard's book. Remember the purple ones that show all the places that a particular statute has been cited? I looked up that statute in the Shepard's book, and then I started looking up case after case that had reckless driving cited within it. I started reading up on it, and it turns out that that reckless driving was just a codification of an old common law charge with regard to gross negligence or something along that line. And because of that, I began to realize why it was that the statute was still on the books. And so then I began to formulate a defense around what I learned from reading those cases. My friend that got charged with the Securities and Exchange Commission, they sent him all this paperwork and so forth. We brought that down. We looked up the statutes that they cited in their paperwork. Then we took those statutes and we started reading the annotations. We pulled out the federal practice guide, and we looked up under administrative law, and we started studying on how administrative law worked. We went to the Code of Federal Regulations for the Securities and Exchange Commission, within those we read up on what regulations they had determined to subject themselves to and how they were going to act upon the statutes that Congress had passed into law. The other thing that happened was that the reason the Securities and Exchange Commission contacted in was under the Right to Financial Privacy Act. They wanted access to bank records. And so we went to the section of the United States Code that dealt with the Right to Financial Privacy Act. We found that by looking in the index for United States Code. We went over there and we started reading that. We shepherdized out the sections of that. When I say shepherds, of course, that's listing all the cases that have discussed the Right to Financial Privacy Act. when we got done, we knew more than most attorneys know about the Right to Financial Privacy Act and whether or not it had been complied with by the SEC. It's still our position today that it was not. And in fact, it looks like my friend has grounds for a lawsuit, or several lawsuits, in fact, springing from that matter. To give you another example, in my federal civil rights case, I wanted to get an injunction pending appeal. I came across Rule 62. I read the rule itself. I looked like that was exactly what I wanted. I went to Wright and Miller on federal procedure, and I read what they talked about under Rule 62. And basically what they described were some criteria that I could meet. So then I went to Bender's Federal Forms, and I pulled out Rule 62, and I looked up sample forms for that. I plugged my set of facts into that and cited the rule, the federal rule, which is Rule 62, and put together a motion on that. Another example would be a civil rights action. Suppose that you felt like that the police had roughed you up somehow. What you would do then is you might look, I know now that it's excessive force is what's described. So then you take excessive force, you go and, well, if I didn't know what they described, I would go to the Civil Rights section of the Federal Practice Digest or the Supreme Court Digest. At the front of that section is a table of contents. I would look down, it's a very detailed, by the way, I would look down the table of contents until I came to something that looked like it might be describing excessive use of force. Then I would go to that section of the Federal Practice Digest and I would start reading annotations. Once you start reading the annotations, you'll get a general feel for what the courts have been looking at, and then you can go look up those cases. Inside those cases are going to be the Supreme Court sites that deal with excessive force, and pretty soon you'll have a comprehensive knowledge on what constitutes excessive force. Another thing that you would want to do is you would want to follow your shepherds across. If for example, say, I'll give you an example of warrants. We were wondering, okay, what constitutes a valid warrant? What have the courts held? In Colorado, a bench warrant was issued for a guy who allegedly failed to pay his fine, who actually did pay his fine. And so now, who's at fault on that? And what do the courts think about this issue? Well, it turns out that there's a Fourth Circuit case out of a federal court, which is not controlling in the state of Colorado, and for that matter, it's not controlling in the 10th Circuit for the federal court system, right? So what you do is you take your Fourth Circuit case that talks about validity of warrants, and you get in the Shepherd's book for that particular case. Then it'll have broke out by circuit where that case was cited. So you follow those around until you get to the 10th Circuit or whatever circuit you're in, and that'll show you every time that Fourth Circuit case was cited in the 10th Circuit. And guess what? Those cases will be dealing with validity of warrants. And so you can pull all those cases out and read the little brief description at the start of it, and now you'll begin to get a full understanding on what constitutes a valid warrant. Some of you might deal with divorces. If you're dealing with divorce, what I would do is I'd go to my state revised statutes. Here we call them the Colorado Revised Statutes. I know in like Ohio, it's called Ohio Revised Code or whatever. Look, the place where all your state law is codified. Go to the index and look up the term divorce in the index. That'll send you to the state statutes that deal with divorce. You start reading through those statutes until you come to the relevant parts, and then you follow that down and you read all the annotations underneath that, and you start to get a feel with respect to divorce and how it works. You know, after having seen me go through and show you about all these law books and how they work, it may seem a little bit overwhelming. But let me assure you that after having spent just a few days at the law library doing legal research, it won't be very long and you'll feel like an old hand at this. And knowledge of how to use a law library will be a skill that will serve you well for the rest of your life.